Kip, here's a legal question for a lawyer, I suppose, from Donnie. Donnie had to actually sign an arbitration agreement when his mom went into a nursing home several years ago. Is that agreement still enforceable? Or if Donnie wanted to retain an attorney, is there a possibility to go to court, or do you have to sort of go in front of the arbitration panel?
Donnie, that's a great question. And we see this quite a bit. Most of the time, whenever you are checking or admitting a family member into a nursing home, they present you with a pile of documents, and buried within that document or that pile of documents may be an arbitration agreement. There's a lot of factors that go into determining whether or not that agreement itself is binding. First and foremost, did you have authority to sign it on behalf of your mother or your loved one? Was your loved one competent? Could they have signed it themselves? Was the document presented to you and explained to you? Is it fair and reasonable? All these different factors come into play. Certainly it does not prevent you from bringing a claim. It just prevents the location or the venue for that claim. And if you're in arbitration, you're before a panel of lawyers, whereas you otherwise might be before a jury in a location near the nursing home. So it certainly doesn't inhibit you from bringing a claim. It is something that if you have an issue of neglect that you think is actionable, it's worth engaging a lawyer to take a look at. And we fight arbitration agreements all the time in court, and it's something that it can be overcome, and you can proceed ahead before a jury in the locality where you're living.
Neil, let me ask a follow-up question here. Kip, I don't mean to put you on the spot, but everybody should know you're licensed in both Georgia and South Carolina. So are the rules different with regard to arbitration clauses in Georgia versus South Carolina?
Yes, and I appreciate you putting me on the spot. I will say that I think the rules in South Carolina, or at least the rulings in South Carolina, have been a little more favorable with respect to plaintiffs and allowing them to proceed ahead before a jury rather than in an arbitration format. Georgia has been a little more reserved in that regard, but we've had some rulings here lately that have changed the law in Georgia a little bit. And so I think folks are realizing and judges are realizing that many of these agreements are put before this family member or loved one who's under a great deal of stress and is hurrying to get their family member admitted into the facility, and never have the opportunity to actually, one, read the agreement, or two, understand what it's about. And certainly, if you're within a certain time period, many of them allow you to revoke that agreement. And that's something that if you recently had a loved one admitted and think you may have signed one, it may be worth sending a notice letter to revoke any arbitration agreement that had been executed in that particular instance. So.